all of you for lending me your ears, and hope that I have contributed to a better understanding and appreciation of what your SEC is doing and will continue to do as our contribution to nation building and to securing a better and more comfortable life for all. Thank you very much and good afternoon. Back to you, General.
Thank you very much, Commissioner J.V. Francisco. That indeed was a very informative orientation about the mandates and functions of the SEC. Now we'll go to the second part of this session, which will discuss one of the mandates, which is SEC as a corporate registrar. I'm honored to introduce to you our second resource person for this afternoon. Our resource person is also a lawyer and a graduate of Ateneo de Manila School of Law and was appointed the Securities and Exchange Commissioner on 25 of January 2019. As SEC Commissioner, he is the chairman of the Task Force on Ease of Doing Business, Protecting Minority Investors, and the co-chairperson of the SEC Community to operationalize the revised Corporation Code provisions. Prior to joining the Commission, he was an Assistant Secretary in the Office of the Executive Secretary of the Office of the President, where he was also designated to sit on the board of the Subic Bay Metropolitan Authority. Before entering government service, our speaker also practiced law in Davao and in Manila. He began his career as an associate lawyer of the Sigyon Reyna Montesilio and Osiaco Law Office, and he was also an opinion and legal columnist of the Sunstar Davao newspaper. Ladies and gentlemen, let's all welcome Attorney Kelvin Lester K. Lee.
Good afternoon. Thank you, Journal, for that very kind introduction. So without further ado, let me get to the discussion. To Chairperson Emilio Aquino, to the Commissioners, Com F, Com JV, Com Carlo, to our directors, assistant directors, our dear SEC employees, and to our friends in the private sector, various organizations. A special mention, of course, to Chairman of PIFA, Sir Mike Ferrer. I work closely with him, so I'm glad to see that, to hear that you're also supporting us here. A pleasant good afternoon to all of you. Thank you for this opportunity to discuss the salient provisions of the revised Corporation Code and the different guidelines and memorandum circulars we issued to operationalize the revised Corporation Code. Now, before I really get into it, please note that due to the length and breadth of the new law and due to the limited time I have now here, I might not be able to comprehensively discuss all of the provisions of the revised Corporation Code. I will instead try to focus on some of the more important provisions and their operationalizing memorandum circulars. In particular, I will try to limit myself to some of the more prominent provisions which are considered major changes in the law. So with that, let me begin. Next slide, please. The revised Corporation Code was signed into law by the President in Malacanang on Feb 20, 2019. By that point, I was already with the Commission. And as an aside, I was lucky enough to be there to witness the signing of the code with the rest of the SEC and with some VIP. Sadly, I'm not in the picture, however. Neither ComJV, myself, nor the chair are there. Chair had to be abroad for an important matter. And Commissioner JV and I were sadly, because of seniority, we couldn't fit. So I tried to imagine that had there been a little more space, I'd be there besides Commissioner Amatong, the one with the barong on the right side, and ComJV would be with the senators on the left side. No, but anyway, that's life. So the law was published and became effective on Feb 23, 2019. Next slide there. Now, as early as the 15th and 16th Congress, there was already an intention to initiate reform measures through the amendments of the corporation codes and other laws, which could advance the business climate, improve the ease of doing business in our country, and encourage more investments to come in and create more jobs, obviously. Now, it's also envisioned that these amendments would strengthen the system of corporate governance in our country and incorporate, of course, global best practices. Now, the proposed amendments that were going through Congress and that were included finally proved to be so plentiful, so substantial that Congress decided instead to come out with a revised corporation code, a fully new law, no? Instead of just mere amendments as they've done with other laws. And that's why we have the revised corporation code as it stands now. Next slide, please. Now, the revised corporation code is considered self-executing, meaning we can't and we should not issue implementing rules and implementing rules and regulations for the revised corporation code. That's per the legislative intent of the senators and congressmen who drafted and created the law. But please take note that there's still a need to operationalize, some of the provisions of the revised corporation code. And so we're doing that, and we have been doing that through the issuance of different memorandum circulars. Next slide, please. So in line with that, we issued SEC Resolution number 155 on February 25 last year and constituted the committee to create and draft those memorandum circulars to operationalize the RCC provisions. Excuse me. Now it's chaired by Commissioner JV, who spoke earlier, and co-chaired by myself. Next slide, please. A lot of words in this next slide, but essentially it's just more or less outlining the provisions we'll be discussing today. It's all there. I won't go through them one by one now, since I'll be discussing them later on. This will serve as an outline. I also include in today's discussions of the memorandum circulars that are involved, and also some of the draft memorandum circulars which are on our website. Oh, allow me to pitch very quickly our website, www.sec.gov.ph. A lot of our memorandum circulars and information that a lot of people ask me are usually there. So I always try to guide and encourage people to go through our website, look through it, all there actually. Next slide, please. So we'll start now with Section 10. In relation to the Section 10 of the Revised Corporation Code, this provides that any person, partnership, association, or corporation, singly or jointly, with others, but not more than 15 in number, may organize a corporation for any legal purpose. So in line with that, the Commission issued SEC Memorandum Circular number 16, series of 2019 on August 1, 2019. So last year again. No? These are the guidelines of the numbers and qualifications of incorporators under the Revised Corporation Code. This gives the entrepreneur options now for incorporating a new domestic corporation, because as little as 2 incorporators up to a maximum 15 incorporators can already create and generate a corporation. Of course, with exceptions, there are some exceptions involved. For instance, natural persons licensed to practice the profession, subject, of course, to the 11th negative list. And one of the salient features that is discussed very specifically in MC16 is that an individual may not be named as a director if he signs the articles of incorporation on behalf of the incorporator, in behalf of the incorporator / corporation he's representing, except of course if that person is also owning 1 share of stock. So this sort of helps us in implementing and clarifying a lot of the questions that we get in relation to how to implement this. Next slide, please. So the next slide speaks of a corporation's perpetual existence. In case you didn't know it, corporations are literally forever now. Under Section 11 of the Revised Corporation Code, it provides that the corporation shall have perpetual existence unless its articles of incorporation provides otherwise. So the most eye-catching provision of this part is that a corporation can now exist beyond the old 50-year terms provided by the old Corporation Code. It simply states that corporations with certificates of incorporation issued prior to the effectivity of the Revised Corporation Code, and which continue to exist now, meaning not revoked or anything, shall have perpetual existence. And this comes into my running joke, and don't tell my wife this. Yes, ladies and gentlemen, love may not be forever, but now corporations are literally forever. And I hope my wife didn't hear that. So an exception to the perpetuity rule, the perpetual rule, is when the corporation, upon a vote of its stockholders representing a majority of its outstanding capital stock, notifies the SEC. So in short, notifies the SEC that they don't want to have perpetual terms. So in short, a corporation can elect to inform us through the correct number of votes provided by the Revised Corporation Code and tell us that they want a shorter term. They don't want to be perpetual. They don't want to be forever. Frankly, I don't quite see what advantage there would be to not be forever, not unless there are other legal provisions that perhaps limit their lifespan. But well, we of course defer to the wishes of the corporation. And in relation to that, corporations will have a 2-year period from effectivity of the code to inform us whether or not they want to be forever, so to speak. So since the code was effective on Feb 23, 2019, they would have corporations, all corporations would have till late February 2021 to inform us whether or not they want to be a perpetual corporation. Whether they opt out of being a perpetual corporation. If you want to remain a perpetual corporation, a forever corporation, then you don't have to do anything anymore, right? Next slide, please. In relation to that provision, we also issued Memorandum Circular number 23, which are the guidelines on the revival of expired corporations. Under this, I won't go through the nitty-gritty details. Anyway, it's on, once again, it's on the website. Once again, it's www.sec.gov.ph. But the point of this Memorandum Circular is to operationalize how to revive a corporation, a revoked corporation, under the current revised corporation code. And of course, when that revoked corporation is revived, then it will be forever na naman, no? And it, of course, it would retain all its rights and privileges subject to the duties, debts, and liabilities existing prior to that revival. And once again, as I mentioned, it gains perpetual existence unless the application provides for a specific term. Next slide, please. Section 12, this is pretty simple. It's just in the law. It says that stock corporations shall not be required to have a minimum capital stock, except as otherwise provided by special law. So there's no longer any minimum requirement now. This is an ease of doing business initiative, and it has been useful for us in the sense that it encourages people, because even with minimum capital, no minimum capital, you can already incorporate. But to be candid, of course, you are unlikely to create a corporation or generate a corporation if you don't have the funds to support it. So I don't actually foresee this being used much, except for academic purposes, and of course to showcase the fact that almost anyone can now create a corporation. So which helps encourages, once again, business in the country. Next slide, please. We also changed through our revised corporation code the corporate name threshold. Section 17 of the revised corporation code provides that no corporate name shall be allowed by the commission if it is not distinguishable from that already reserved or registered for the use of another corporation. This was operationalized by SEC Memorandum Circular number 13, which provides for the amended guidelines on the use of corporate and partnership names. So specifically, there's been a shift from the old confusingly similar threshold under the old code, or old corporation code, to distinguishability in disputes regarding corporate names under the revised corporation code. This will theoretically make it easier for people to reserve corporate name because the threshold now is distinguishability already, so it's a little lower. Next slide, please. Section 22, qualifications of board of directors. Term of a director is still 1 year, while a trustee for non-stock should not exceed 3 years. Now, the important provisions here in that, the important wordings here is those for enhanced corporate governance under Section 22. It pertains to the increase of independent directors in the company's board, where corporations vested with public interest are required to have at least 20% of the board consisting of its, to have independent directors consisting at least 20% of the board membership. Okay. Now, as an independent director is a person who, apart from shareholdings and fees received from the corporation, is independent of management, free from any business or other relationships which could reasonably be perceived to materially interfere with the exercise of independent judgment in carrying out their responsibilities as a director. And as you see on the screen, we already have some examples of those corporations that can be considered with public interest and thus subject to the 20% threshold for independent directors. So next slide, please. Section 24 provides for the corporate offices of the corporation, corporate officers of the corporation. It states that the president must be a director, a treasurer must be a resident, while the secretary must be a citizen and resident of the Philippines. Now, Section 24 of the new code also provides for corporations vested with public interest, the board shall be required to elect a compliance officer. So more jobs for us lawyers, because more than likely a compliance officer will be a lawyer. So now, and lastly, another provision to discuss is that any two posts can be held concurrently except president and secretary or president and treasurer at the same time, unless otherwise allowed by law and by us in the commission, right? Next slide, please. Section 28 provides for vacancies and the emergency board. Next slide. There. Section 28 there. So that's fairly basic. If you read the law, it's all still there. It just states the method for how to fill vacancies if in case someone has an expired term among the board. What is interesting there, and it's new, is the provision on the emergency action, what we call the emergency board. Um, Under Section 28, an emergency board and emergency action is permitted when a vacancy in a corporation's board prevents the remaining directors from acting or from constituting a quorum. So they can constitute a quorum, and consequently, that particular board cannot make emergency actions required to prevent grave, substantial, and irreparable loss or damage. So this envisions a situation where talagang may emergency, they can't do anything about it because there's no quorum. How do you deal with that? Because the normal provisions of law would not suffice to save the corporation from the repercussions of such emergency. So that vacancy can now be temporarily filled from among the corporate officers of the corporation by unanimous vote. So the remaining board would then choose the emergency board director to sit, but it has to be unanimously chosen, and he would be the emergency board director. And then the action by that designated board director, the emergency one, is only limited to the emergency action necessary, and the term of that emergency director is supposed to cease within a reasonable time from termination of the emergency. So it's only for a very limited purpose, but at least now there is a provision to help the corporation in emergency situations. And of course, you have to inform us at the SEC within 3 days from creation of that emergency board, and of course, explain to us and state the reasons thereof. So there, next slide. Section 29 provides for compensation of directors or trustees. So in theory, there should be no, by law, there should be no compensation for directors except for reasonable per diem. And then total yearly compensation is now limited, 10%. So it's there. I just like to point out the interesting provision. Well, at least to me, it was very interesting. Corporations vested with public interests are supposed to submit an annual compensation report of the directors or trustees to their shareholders and to us at the SEC. So in the same way that now we public servants, Commissioner JV, myself, and the other commissioners and the chair and all our other SEC employees are required to submit SAL-N, and we're required to inform through the COA our compensation. We can also now see, in theory, the compensation of the board directors of those corporations with public interest. So fair lang, no? Kita mo sa akin, I can see yours as well. Anyway, next slide. There's a limitation now on the dealings of directors, trustees, and officers within the corporation. This is to avoid those self-dealing, what's the term again? This is to avoid problems in terms of contracts that are disadvantageous to the corporation and advantageous to those directors, trustees within the corporation. Kumbaga, to avoid the conflict of interest situation that does sometimes happen. So situations like that, contracts of directors, trustees, or officers, or their spouses and relatives within the 4th degree of consanguinity or affinity are now voidable at the option of the corporation, unless, of course, these provisions are number 1, the direct presence is unnecessary to constitute a quorum. The vote, number 2, the vote is unnecessary for the approval of that contract. That contract is fair, reasonable. For corporations naman vested with public interest, material contract should have been approved by at least 2/3 of the board's entire membership, with at least a majority of the independent directors voting to approve that contract. And in the case of an officer, the contract was previously authorized by the board of directors. So there are safeguards. Now, the long and short of it is that this corporation code now provides for safeguards to avoid conflicted contracts or self-dealing contracts, which usually are detrimental to the corporation. And of course, to the advantage whoever that director or trustee or officer was. So the limitation is pretty clear. Next slide, please. The next provision refers to the participation of stockholders. Oh, sorry, next slide, please. There, remote communication there. So the next provision talks about the participation of stockholders in their respective meetings and voting by remote communication or absentia. So under Section 49, this is to ensure the day-to-day operations of corporations and compliance, of course, with the regulatory framework, so that directors, trustees, officers, and stockholders are now allowed to attend and vote in meetings through remote communication devices. So the law has already set up the possibility of digital meetings, electronic meetings, virtual meetings. So because even electronic notices and meetings are already allowed as provided by this provision. Even the right to vote, exercise in person, or when so authorized in the bylaws, are also allowed through such remote communication. Now, I'd just like to point out that for directors and trustees, it's very explicit under Section 52 of the Revised Corporation Code that if they cannot physically attend or vote at that board meeting, whether it be through a video conference or a teleconference meeting, they cannot attend or vote by proxy at those board meetings. So meaning to vote pa rin, no, a director still has to be present at that remote communication method of the board meeting. They can't just pass it along because they're not the ones voted in nga naman to vote and decide on the decisions of the corporation. And interestingly enough, this was how our provisions on the SEC Memorandum Circular on Teleconferencing, Memorandum Circular number 15, series of 2001. So it was as early as 2001, before the law was put up in that way. The SEC had already adjusted and already made this available as an option. So it's just now very specific now under the law. So there, next slide, please. These are just on the meetings of directors, regular meetings conducted monthly, special meetings anytime upon call of the president, where anywhere in or outside the Philippines, unless provided by law, by their bylaws, notice 2 days, and then attendance and voting. It can be done in person or through remote communication. No, but once again, I emphasize the point: it cannot be by proxy. Then the quorum requirement is the majority, unless the Articles of Incorporation provide for a different majority or a greater majority. And then obviously the election of officers requires the vote of a majority of all the members of the board. Okay, so that's fairly basic. It's medyo codal na rin. Next slide, please. Section 48 Section 48 to 51 and 57 of the Revised Corporation Code provides for the provisions regarding stockholders meetings. So this earlier we were talking about directors, now we're going to talk about the stockholders meetings. And notice may be given through whatever form of communication is allowed by your corporation's bylaws. Now under Section 49 for regular meetings, we issued a memorandum circular to that effect. The company must now notify the stockholders at least 21 days before the meeting. Once upon a time in the old code, it was 2 weeks, if I recall correctly. Now we are very specific about it. The code is very specific that it should be 21 days. And we further confirmed this through a memorandum circular, number 3, which we issued just this year on the notice of regular meetings of the stockholders. This took effect on Feb 27, 2020. Written notice of regular meetings shall be sent to all stockholders or members of record at least 21 calendar days prior to the date of the meeting. So now it's very specific. 21 days is now the minimum. And once again, this applies to all corporations, right? The rest, medyo basic na rin naman yan, no? It's all there. So next slide, please. Here, participation through remote communication. We also issued this out this year. This was also the memorandum circular that helped ensure that you could hold digital board meetings, especially during times of COVID. And I'd like to point out that the Commission issued SEC Memorandum Circular number 6 before or around the time the COVID was happening. So we were able to have this in place around the time of the lockdown. So medyo naunahan namin konti because we were anticipating that would be the problem, that people would not be able to travel and meet in large groups anymore. So the SEC Memorandum Circular number 6 provides for guidelines on the attendance and participation of directors, trustees, stockholders, and other persons of the corporation in regular and special meetings through teleconferencing, video conferencing, other remote or electronic means of communication. Now, it's clear there, but the interesting portion for this is the transitory provision, Section 16. It provides that in order to immediately operationalize this provision, these guidelines, corporations upon approval of this circular may already conduct their board meetings and stockholders and members meetings through remote communication or the other alternative modes of communication only for the limited purpose of approving the provisions in their bylaws or internal procedures. So how you conduct pa rin yung remote communication and the board meetings would still be would still be dependent, on your internal guidelines and on your bylaws. So, but we had a transitory provision to help you facilitate the conversion to board meetings, to digital board meetings. Once again, if some portions are unclear, I would suggest you look through SEC memorandum circulars on our website. We have a whole provision just for that. Okay. Next slide, please. Section 73, corporate books and records. So this provision provides that corporate records, regardless of the form in which they are stored, are open to expansion by any corporation's directors, trustees, stockholders, or members, in person or by a representative at reasonable hours on business days. And they can demand in writing, which would be made by those, they can demand in writing made by those directors, trustees, stockholders, no, that they can copy those records or extract from said records. It also states that anyone who refuses that request, that stockholders valid request, would be liable for damages. In addition, is supposed to be guilty of an offense under the penal provisions of the revised corporation code under section 161 of the revised corporation code. Now, there are defenses, of course. Now, if such refusal is made pursuant to a resolution or order of the board, as I mentioned, the liability would go now to the board or whoever ordered it. But the defense would be that the person demanding to examine that or copy extras of that corporation's records is, number one, improperly using that information. Number two, was not acting in good faith or for a legitimate purpose in making that demand. And number three, is a competitor, director, officer, controlling stockholder, or otherwise represents the interests of a competitor again. So in case of the corporation's denial or inaction of a demand for inspection or reproduction, the aggrieved party, the one who wants to look at the records, they can actually file it now with us. Section 73 provides for that as well now. So the SEC can then, once the report is filed with us, the SEC is mandated to conduct an investigation of that report and then issue an order directing the inspection or reproduction of the requested records. Now, how did we operationalize this? If you go to the website, next slide, please. No, sorry. If you go to our website, there's already a draft proposed guidelines. Let me just read the term. No, it's a proposed guidelines in conducting investigations of violations of the right to inspect and or reproduce corporate records. It's there on our website for official comments. For publication, and we've been requesting for comments from the public, and that is how we will implement this. So in case you have an issue, meaning you are not being allowed to inspect the corporate records, then you can file a verified report in case of denial or inaction, and you file it with the CRMD, the Company Registration and Monitoring Department. And these are the grounds for violation: outright refusal, failure to take the necessary steps, failure to give a reasonable amount of time to produce records. So it's not a reasonable clause then to allow them to look at the corporate records and then just give them 5 minutes to look at it and photocopy it. Obviously, that's still a violation. Failure to take the necessary steps, failure to give a reasonable amount of time to reproduce corporate records. So I suggest, if you want to go over this, anyway, it's not final yet, but I wanted to point it out because most of us have gotten a lot of questions about this, how to operationalize, how to use that provision of the revised corporation code. And so that's what is supposed to, that's supposed to be the binding and guiding document now in relation to this. It's on the website. Once again, I emphasize that. Please take a look, then let us know what you think before we formally approve it later on. We're scheduled to approve this soon. Next slide. Okay, we're here now at the one-person corporation. So what's a one-person corporation? So a one-person corporation is a corporation, to make it simple, no, it's a corporation with a single stockholder. And this is the one that's supposed to take over and sort of remove the idea of you using a single proprietorship. Now, kumbaga, you're being encouraged to use the one-person corporation instead, because it's simpler. In effect, it's simpler, it's easier, and you have all the legal protections provided by law according to a corporation. So an OPC, as you can see, is composed of a single stockholder who should be the sole director and president of the OPC. OPC pala, no, or one-person corporation. So now, like I said, we're seeing that this could take the place of a sole proprietorship because obviously it's more advantageous. You have a single owner, but all the protection of limited liability provided to corporations. And as of February 2020, there's around 2,000, I think, already OPCs already registered. We haven't been able to update it yet because of our difficulties with COVID, but I'm sure there's more than 2,000 by now, either being incorporated or already incorporated by us at the SEC. Now, in fact, we believe that the creation of an OPC especially beneficial in an economy where the micro, small, and medium enterprises comprise more than 90% of business establishments in the country. And it's these small corporations that generate around 63% of the jobs in the country. So of course, we want to encourage it. And in fact, the creation of the OPC allowing this by law has also helped us in the ease of doing business numbers rankings in relation to the bank. No? So this has been useful, and there have been, in effect, this has been one of the more important provisions of the revised corporation code. Now, to the nitty-gritty details, there seems to be a conflict within Section 116, because the first paragraph of Section 116 states that only a natural person, trust, or an estate may form an OPC. However, the second paragraph naman states that the trust may not incorporate as an OPC. This conflict is resolved by interpreting the first paragraph as referring to the subject trust being managed by the trust entity, and this is clearly provided for now in SEC Memorandum Circular number 7, which are our guidelines on the establishment of a one-person corporation. Now, the trust itself naman, as used in the second paragraph of Section 116 is supposed to refer to the trust companies. So in short, the trust itself can incorporate as an OPC, while trust companies cannot, right? And MC7 also states that at the time of incorporation, if the single stockholder is a trustee, administrator, executor, things of the like, he has to submit the proof of authority to act on behalf of the trust or estate to the SEC before he can incorporate an OPC for that purpose, right? Anyway, next slide. Question: can a foreign natural person form an OPC? And the answer to that would be yes. Although this is subject to the applicable constitutional and statutory restrictions on foreign participation in certain investment areas and activities. So in that situation, I recommend you go through the 11th negative list, EO number 65. There is a list there of those corporations, those business entities wherein foreign ownership is limited by the mandate of the Constitution and by specific laws. That would be helpful for you to determine which one you can or cannot form such corporations. Now, in order to incorporate an OPC, how do you do it? You only have to submit your articles of incorporation with the required details as provided by the Memorandum Circular number 7 of 2019, which includes the primary purpose, principal office address, things of the like. Next slide, please. Now, like any other normal corporation under the revised corporation code, the OPC also does not require a minimum capital stock anymore, except as otherwise provided by special law. So, and of course, MC7 also provides that unless otherwise required by applicable laws, rules, or regulations, no portion of the authorized capital stock is required to be paid up already at the incorporation stage. So, once again, if you want to clarify further details, I would recommend you look at the memorandum circular, which operationalizes this. Oh, and no bylaws are required now for the one-person corporation, because the bylaws are supposed to be the rules for how to run a corporation. But if you're the only person running the corporation, it doesn't really make sense for you to have rules for yourself. Not at least not in those, not in the current setup. Next slide, please. Conversion, right? The one-person corporation provisions under Section 131 and 132 explains how you can convert from an ordinary stock corporation, what we call an OSC, and then convert it to an OPC, an ordinary one-person corporation, and vice versa. Section 132 provides naman for the conversion from a one-person corporation to OSC. And this I want to highlight. Again, we have a proposed guidelines for conversion corporations either to OPC or vice versa. And once again, that's on the website. I encourage you to look at it. The guidelines currently provide that if you want to convert one way or the other, OSC, one ordinary stock corporation, or to OPC or vice versa, you simply submit no conversion articles of incorporation or bylaws as may be applicable to the SEC CRMD. Now, the conversion will, of course, result in the remaining corporation, whether it be an OPC or OSC, being legally responsible, succeeding the old corporation and being legally responsible for all of its outstanding liabilities as of the date of conversion. So anyway, that's fairly simple as well. Next slide, please. Now, we were talking about the OPC, and earlier we had talked about the 2, 3, 4 5 kinds of incorporations corporations. No? And I'm happy to announce, although we've already announced this before, that we created an interim online registration system for OPCs, one-person corporation, and corporations with 2 to 4 incorporators online. There's an interim online registration system to facilitate applications to that effect. And it's here on the website. I suggest, I encourage you, go check out that website if you want to incorporate and try it out. No, I'm happy to say and very proud to say that this was a homegrown thing, meaning our own developers within the SEC, as well as with the help of our processors from the company registration and monitoring department. We're the ones who work together to create this under the guidance and leadership of our Commissioner JV Francisco. So I encourage you to try it, especially now during times of COVID. It does help that you do this online. Next slide, please. The next slide talks about our powers and authorities and the jurisdiction of the Commission. This is fairly basic as well. It's all in the codal. I'd just like to point out that some people have asked about our jurisdiction. Well, very clearly in the law, Section 179 provides that we have supervision jurisdiction over all corporations and persons acting on their behalf. I'd also like to point out that we have the power to impose sanctions over violations against the revised corporation code and whatever provisions, memorandum circulars that we issued because of that, and those who do not follow our orders. We have another provision on promotion of corporate governance and protection of minority investors. And we also have the power to suspend or revoke the certificate of incorporation of a corporation after proper notice and hearing. So this encapsulates our increased powers as a commission. We have stronger enforcement powers now. I'd also like to point out that no court below the Court of Appeals have the jurisdiction to issue a restraining order, preliminary injunction, or preliminary mandatory injunction against us now at the SEC. So RTCs, RTC Regional Trial Court, Metropolitan Trial Court. So any court lower than the Court of Appeals cannot issue a TRO against us. And despite the clear word, the reason I emphasize this is because despite the clear provisions in law now, we have had the sad experience of some lower courts issuing TROs against us. Perhaps they haven't seen it or they haven't read it yet. We had to contest it with some of the higher courts, and thankfully we won. No? Thankfully we were able to overturn those incorrect TROs. But it bears noting that you can't TRO us that simply anymore. Thank you. Next slide, please. Electronic filing and monitoring system, Section 180. So is online registration possible under Section 180? Yes, no. We are doing it now. As you've seen, created the online registration system for the OPC. We're also using the CRS, the company registration system, which we plan to improve and potentially use something newer later on through some grants. But essentially, Section 180 mandates the SEC to develop and implement an electronic filing and monitoring system. So in line with, we have done some actions different and issued different memorandum circulars that are in line with that provision on having a more digital SEC. One of them, and that's next slide, please. One of them is the SEC notice April 8th, which I mentioned pertains to the online registration system for OPCs and corporation 2 to 4 incorporators. Sorry, next slide, please. There. And this is another one, section, SEC Memorandum Circular number 16, series of 2020. These are the guidelines on authentication of articles of incorporation. This isn't strictly speaking an electronic filing thing, but it does help in relation to that, because now under this memorandum circular, we are lightening the requirement in relation to notarization. Under this memorandum circular, and I encourage you to go over it, registration with a certificate of authentication signed by all incorporators is now sufficient. So notarization isn't strictly speaking that required anymore. You can still do it under Section 3, and if it's abroad, you can still apostille under the appropriate convention. But general rule now is you can already consider not doing it through notarization, which is useful, especially during these times when you can't really go out. It's fairly difficult to go out. No? So I just wanted to emphasize this and point it out and encourage you to look at it. SEC Memorandum Circular number 16. Okay, and this is something which was prepared and issued under, once again, the guidance and assistance of Commissioner JV Francisco, and I'm sure we are all very proud of this particular provision as well. Next slide, please. Here, this is a draft circular connected again in relation to Section 180 on electronic filing and monitoring system. Now, when I say draft, it's still website, it's still up for comments, but I wanted to pick up because it shows you the direction we're going. No less than the president has said that we should have a more digital government now. We should do things online as much as possible in light of everything that's happening. And in line with that, this draft essentially says that corporations, associations, partnerships, and everyone else who transacts with the SEC are now required to submit a valid official email address and a valid official cell phone to the SEC. Why? Because this is how moving forward, we intend to transact with you now. Okay, you are supposed to do it online. You're supposed to do it through email and through phone numbers as much as possible, right? Now, you are also supposed to submit an alternate email address and an alternate, excuse me, alternate cell phone number. Okay, and I cannot emphasize this enough. Whoever's incorporating for you in your corporation, or whoever has custody of your email address or cell phone number, you have to make sure it's someone you trust and someone who represents the corporation, because we intend to hold you to it. Whatever email address, whatever cell phone number is on file with us will be binding on you. No? So with this, we hope to move most transactions more quickly, including some of our administrative investigations. Next slide, please. Oh, this is the interesting part. I actually found this funny. Sorry. Back one slide. I just wanted to discuss something very quickly. Back one slide on there. There's something I found a little funny. There was a provision there in the draft circular providing for the situation where there is no internet, supposedly at the place of incorporation, at the place of doing business of the corporation that is coming to transact with us. In the case that there is no internet access, then you will have to submit instead a official and alternate cell phone number, no? But you also have to submit a certification, and you have to inform us that in your supposed inability to create an email account due to lack of internet access in the principal office of that company. And then you are supposed to where's that again? There. You're supposed to inform us and certify that you will inform us of that official email address within 30 days from the time the area gains access to the internet. This is something that, kumbaga, we have a transitory phase in case you are unable to submit to us that and supposedly have no internet access. But in light of the fact that we're all going online, we're all improving, the companies are now improving their internet access, I don't think this should be an issue anymore, but it's there. So kumbaga, you can't quite escape that requirement from us now. Anyway, next slide. I think I'm about done. There, arbitration. We're talking. The revised corporation code also provides that an arbitration agreement may be provided in the articles of incorporation or bylaws of a corporation if this is in place. Now, disputes between corporations and stockholders that arise from the implementation of the articles or the bylaws may now be referred to arbitration. So this is a faster dispute resolution system. It's a better way of decongesting our courts, I think. But please note that criminal offenses cannot be subject of arbitration. And this is important as well, because if an intracorporate dispute is filed with the regional trial court, the court is mandated to check if there is a arbitration clause, and if there is, then they can dismiss that case. So this is something I encourage actually to try and decongest our courts. And we are in the middle of drafting our draft memorandum circular in relation to arbitration clauses. We're actually speaking to the Philippine Chartered Institute for Arbitrators on this. They are assisting us on this. I'd like to make a special shout out to the attorney who is helping us in particular, my old friend, Attorney Jay Santiago, who is assisting us on this. If he's listening, I hope he is. So I mentioned specifically for his assistance. But anyway, we are moving forward with that. We will upload that soon once we have the draft circular as well on arbitration clauses for the SEC. Now, next slide. Now, before ending my presentation, I'm about done. I just like to point out there are other provisions I was unable to discuss because this has been lengthy. And if I went a little fast, I apologize. It's just that this thing was so long, and I was informed I have a very limited time. And these are the other provisions that I believe should also be looked at, because these are some of the newer provisions as well in the revised corporation code. If you have if you have anything further you want to look at in relation to the SEC NR issuances, once again, I emphasize, please check us out. Please check out our website, www.sec.gov.ph. No? We have many notices and circulars which could probably enlighten you in how to deal with things in relation to the SEC. Next slide. Now, having discussed all this, after we were able to gain some insight on these provisions, if you have any further questions or clarifications, please feel free to email us and we'll try to answer them the best we can. I hope this has been helpful. So allow me to end this discussion with the SEC's motto. No, it's easy at SEC. Thank you and good afternoon. Back to you, Journal.
Thank you very much, Commissioner Kelvin Lee. That was really very informative. So we will now go on to our question and answer. And before that, I'd just like to make an announcement for those who have registered in our webinar. For those who have signed up, rest assured that the Commission has recorded your registration. We will send you an evaluation form after the webinar as part of the verification process for your attendance, participation in the webinar, for the issuance of your e-certificates. Thank you very much. Now, for the question and answer, we were able to get a lot of questions, but we will not be able to read all of them. So I'll be reading the questions, the majority of the questions. And later on, if we have time, we would be giving some questions to those who are registered via Zoom. Thank you very much. So we'll now go on to the first question that we got. The first question is, in this time of pandemic, what are the new normal processes in SEC that will help the business sector? This is quite a general question, but they would just like to know, commissioners.
JB, I'll pitch in first, and in case you have anything, please feel free to jump in after. No? In relation to COVID, I just like to point out that that's a very general question, kasi Journal, no? But I just like to point out that I'm pointing you again to the website. No? On the website, www.sec.gov.ph, we have a certain portion there on COVID-19 related issuances, meaning the different memorandum circulars and notices informing the public of extension of deadlines, for instance, for audited financial statements and GISs, the website, the email addresses you can submit online some of your requirements now, the memorandum circulars on electronic meetings now instead on remote communication meetings. So it's there. I would encourage you to take a look at that website. At that particular portion of the website. No, medyo comprehensive naman nandun. And in case there are questions, and of course you can email us separately. There's also a list of the email addresses and the particular concern the department with the particular concern you might have. So I keep pushing people to the website because it's all there really, and it's a good website. Now, not to toot my own horn, but I believe it's a good website. Now, JB, sorry, in case you have anything else.
Yeah. You practically covered it all, Kels. But I would just like to add that we also have hotline numbers just in case you need the information, like during the MECQ status that we have now, we were working only on a skeleton for workforce basis. So, but we have cell phone hotlines which we've also posted on website for any particular concerns. And these assigned cell phone numbers are assigned to particular types of concerns. They're also listed in the website. So there are specific assignments for these cell phone numbers.
Thank you very much.
Yeah.
This is a follow-up question, I think, from the first question, sir. In line with the long-lasting effects of COVID-19, is full digitalization and automation of company registration in corporation process feasible?
Yes, we are going in that direction. No, you've seen naman that we created a new interim website for company registration for OPCs. No, under the guidance of Commissioner JV. We've all talking to ADB and other institutions in relation to creating separate company registration systems later on. We're also currently, very soon, we will soon deploy an online payment portal whereby you can pay online na, no? Through, I can't name the company yet that we're working with, no, because it's not yet officially announced, but we are going in that direction naman talaga. No? We just have to hurdle some of the legal requirements that are mandated by government. But we are going in that direction. No? Ang dream nga namin ni Com JV and the rest of the commissioners and ni Chair is that this can be a one-stop thing, meaning fully online na sana lahat. No? But we will try. We're working in that direction. Com JV, sorry, in case you wanted to say something.
Yeah, I was going to say that the SEC has a very comprehensive digital transformation roadmap, you know, which we're following now. It's not just registration, but everything from registration to monitoring to case management, document tracking. So both customer-facing applications as well as internal systems. So it's an ambitious program, but we feel that as the gateway to Philippine business, we have to be the main aggregator of data and all these systems. In fact, the overarching goal that we have is that, as I mentioned earlier, that we would be like the PSA, you know, of the corporate of corporate governance. So such that all other government agencies we can share information and data with all government agencies. So, for example, if you have if you want to know if this particular corporation is paying the right taxes, so I mean, there's an exchange of information based on documents that are peculiar to particular government agencies. So that's the general track that we're going to. Thank you.
Okay, sir. Now we have a question, sir, here on the one-person corporation. The question goes, what is the purpose of the law in allowing a one-person corporation? That's the first question. The follow-up question is, does establishing one-person corporation help small, medium enterprises to encourage more entrepreneurship and the formation of small businesses?
JB, would you like to take that?
Yeah, okay. Well, basically, the one-person corporation it sort of merges the best traits of a single proprietorship, which is essentially complete dominion over your business, no? And at the same time, limited liability of the corporation. So, and for an entrepreneur, and going to the second question, but before that, so when we say limited liability, because it's the corporation is a separate legal entity altogether, so these, unlike in single proprietorship where all liability is attached to the individual, in this case, if the one-person corporation being a separate entity generally has a separate liability from that of the individual owner. And for SMEs, for example, they could be an advantage, especially when you go into contracts with other entities who may want to be assured of some sort of continuity, you know, because in the case of OPCs, we have nominees, alternate nominees, just in case something happens to the original OPC, you know, things like that. Of course, and then these are, because it's a corporation, it's still required to submit the reports, so easily verifiable by the public. Yeah, that's back to you, Journal.
Journal, can I just add something about OPC? Okay, the main purpose of having the one-person corporation is to allow, like before, we have the traditional 5-member stockholders, no? So this has long been practice as a business organization in other economies or other jurisdictions. So we decided that partly as our initiative towards ease of doing business, you don't have to get like getting your driver, getting your your helpers to join you just so you meet the 5 minimum requirements for incorporators or directors. So this time around, you're just one. You can already run the show. It's a one-man show, which is normally true for a lot of our businesses for MSMEs. I think the other thing, I'd like to borrow the description given by Dean Villanueva, that this is an incorporated sole proprietorship. Okay, it's an incorporated sole proprietorship. Now, there may be some concerns about the tax side of it, but if you will be grossing so much, I think when you reach 8 million pesos in revenues, it will already be competitive for individuals. Okay, but of course, there's this move now by the Department of Finance, which is to push for lower corporate tax rate from the present 30% to down to 25, then later on to 20%. So it will pay off later. But as it is, probably I can share you a tip. If you will notice, we're launching the REIT. We're going to have one that's going to be listed with the PSE of late. Now, the REIT is mandated to dividend out at least 90% of its revenues. Okay, so a dividend in favor of a corporate entity is exempt from taxes. You see, but if you're on OPC investing in a REIT, you'll probably get free. Okay, you will get free or exempt taxes by being an incorporated entity. I think that's just a tip. There's so many other advantages for it.
Okay,
Thank
you
you, Chair,
very
for
much,
that. No,
Chair.
there. Go ahead, Journal. Go ahead.
Uh, it seems that a lot of our viewers are concerned with the one-person corporation. There is another question, sir. The question goes, whether a person with a dual citizenship is allowed by law to establish a one-man corporation reserved exclusively for Filipinos. Talking about the nationalized business.
Journal, that sort of goes back to what I said earlier, that in theory, a foreign national can incorporate as an one-person corporation. But of course, it would be subject to the 11th negative list, no, EO 65. There are limitations provided for there. For instance, some particular corporations are not allowed to incorporate as may contain foreign ownership, things like that. So it would depend. As a general rule, yes, subject to mga ganito na requirement. So I would suggest that whoever's asking that, take a quick look at the 11 negative list and to take a look at kung applicable ba sa kanya or not. Thank you.
Okay, sir. So I think we also have fellow government employees who joined in. And the question, sir, is, can government employees act as incorporators to corporations?
Come, JV. I think this one fits your bailiwick. Thank you.
The general rule is that yes, you can be an incorporator. You can. Governmental employees are not generally prohibited from participating or even holding stock in government in corporations. But that's a general rule. As long as you disclose these investments in your statement of assets and liabilities, then it should be fine. but the government employees also have to take note that there are particular type, there may be specific government agencies that have prohibitions against investing in certain types of corporations, especially those that you regulate. No? So they might as well check also with their respective agencies if there are special prohibitions in that respect. Back to you, General.
Okay, thank you very much, sir. We have another question that is in the membership as a trustee. The question says, can juridical member of a non-stock corporation, such as a condominium corporation, run as a trustee in the board?
Journal.
Parang
Can I
I
respond
don't.
to that? Can I respond to that? Okay. I think the question. Okay, I'll just put on my. Okay. First, there's this specific provision in the RCC or even in the corporation code that directors and trustees cannot act on base of by proxies. They have to act on their own. Okay, so if you have a corporation, a juridical entity, sitting as a member of the board, it will necessarily require one of its members or one of its directors to act accordingly. So in which case, that's not allowed.
Thank
So
you
it
very
has to be an
much,
individual.
Chair.
Okay, thank you.
We have a question here. The question is, can we cite any criminal liability of corporations or legal persons?
Kelvin, I think you have a listing
Chair.
under Title 16 of all the offenses and penalties for corporations.
Yes, Chair. Yes, Chair. If you look at the provisions of the revised corporation code in relation to those that can be held liable, it usually refers to not necessarily the corporation, but those who are involved in the corporation, whether it be the directors, the trustees, things of the like. So general rule, the liability attaches not necessarily to the corporation, but personally to the persons involved, meaning the directors and the courts, the directors, the trustees, the corporate officers. But I'd like to point out there have been some Supreme Court decisions essentially saying that the corporation can be held liable. There was one case in relation to the SSS. I forget the name lang, it's a hotel versus SSS. That there was a violation of the SSS collections na provision. Ambassador Hotel yata or something, I think. Anyway, what happened there was that they pierced the corporate veil and then they held the corporation liable for that violation of non-payment of the SSS fees, but they punished and penalized and fined, I think, the incorporators, the board members and the trustees instead. But they went through the whole process of piercing the corporate veil. So general rule, medyo pwede na, it seems, the jurisprudence seems to be pointing in that direction. But for practical purposes and obvious purposes, you can't really, because you can't have the corporation itself be hauled to jail. So clearly you're gonna have to go dig down, and ang matatamaan talaga would be the directors, the stockholders, things of the like. Thank you.
If I may be allowed to add, under Title 16, particularly sections 159 henceforth. Okay, as what Commissioner Kelvin was saying, the one liable would be the directors, trustees, and the officers. Now, but there is also a specific provision stating there that the corporation may be held liable in the sense that it may also be it can also be committed by a corporation. It's Section 170. Okay, the Kelvin, this is the catch-all provision. Okay, where it states other violations of the corporation separate liability. If the violation is committed by a corporation, the same may, after notice and hearing, be dissolved in appropriate proceedings before the commission. Okay, so if you will note, Commissioner Kelvin was saying you cannot jail the corporation, but as part of the penalty, it is possible. It is possible for the corporation to be meted the corresponding penalty of dissolution or penalties or fines, I should say. Thank you.
Thank you, Chair.
Okay, so I think we have time for about 2 more or 3 more questions. I'd like to say that the chat, for those in Zoom, the chat has been open. And in case you have questions, we could get 1 or 2 questions from you. Now, we have one question here. It's quite long. I'll try to read it. The question goes, Section 22 on independent directors in corporations vested with public interest under letter B, the code mentions corporations engage in money service business. The question is, does this include lending companies and remittance companies?
Okay, can you repeat that? This is with respect to money service businesses, right? And pre-need trust and insurance companies, journal. Is that what was in the question? Okay. Anyway, this pertains to entities which are regulated by the Bangko Sentral. Okay. The enumeration consists of banking institutions, financial institutions, which are regulated by the Bangko Sentral ng Pilipinas and the Insurance Commission, because it includes a pre-need, okay, and insurance companies. Now, as far as the SEC is concerned, we are still crafting the appropriate regulation to identify which of the businesses will be considered as companies vested with public interest. Okay. Now, we are looking most definitely for the financing and companies and lending firms. But if you will note, lending firms, the minimum paid up capital requirement is about ₱1 million, and a lot of them are publicly owned. Okay, I mean family owned, I should say. So in which case, requiring them to have independent directors may be a bit burdensome to that firm as it is, under if it maintains a ₱1 million capital. But as it that's just my opinion for now. But as an commission and bank, we will still have to sit down and craft the proper regulations and identify all the rest of these companies which require which require independent directors in their board.
Okay, so I think we've run out of questions. And is there a question here from Facebook? I'll just read the question from our Facebook viewer. It's still on the one-person corporation, sir. Under the one-person corporation, if that sole person dies, will it automatically be dissolved?
Would like to respond.
No, sorry. Sige, go ahead, JV. Or sorry,
Kelvin.
I was okay. Thank you, Chair. I was supposed to discuss this. I apologize because now the length and breadth of this whole presentation, I was not able to mention the fact that you're supposed to include a nominee and an alternate nominee when you incorporate a one-person corporation. The whole point of having a nominee and then an alternate nominee is that so if the person dies, the person who's the original one-person corporation stockholder dies, the nominee will take over and then will continue operating the business, either wind down or do whatever in relation to winding up that particular OPC. So no, it doesn't automatically die if the person who is the sole shareholder originally died. And precisely why I emphasize this point, you're supposed to mention that you're supposed to submit to us the name of a nominee and an alternate nominee who will take over in case the nominee naman himself dies later on. So,
Okay.
so there, that's the long answer to the question. Chair, sorry, go ahead, Pod.
Probably I'll just add, one of the things or one of the elements for a corporation would be there's perpetual succession. It's there to last. In fact, we are going towards perpetuity or perpetual existence for all corporations, and that includes the one-person corporation. Now, unlike a sole proprietorship, the sole proprietor dies, then the business dies with him or her. If it is a partnership, the death of a partner will cause the dissolution of the partnership. But in the case of a corporation, the death of the incorporators or the directors or the stockholders, it will still survive. Of course, so long as the intention of the owners, the stockholders, is to maintain and continue on with the business, because they can always shorten the term if they want to. But the OPC or the one-person corporation is so devised precisely to allow continuity despite death of the sole director or sole owner. Because precisely there's a provision, as Com Kelvin was saying, there must be a nominee and an alternate nominee even, so that they will be the one to continue the ball. I mean, of course, it's a different story if the heirs, the surviving heirs, decided to just have it dissolved. So there's this option to still continue on. Thank you.
Thank you very much, Chair. Now we have one from the, I think the president of the Integrated Bar of the Philippines, Attorney
compañero.
Domingo Egon Cayosa. He
Our
says,
president.
congratulations to SEC and thank you for this.
Ay,
And
salamat.
he is asking us, how may the Integrated Bar of the Philippines help SEC disseminate the knowledge and information better and faster?
Yeah, in a lot of ways. I think this is a good start for us with this collaboration. I'm glad that our compañeros y compañeras in the Integrated Bar of the Philippines are there and will readily participate as part of the SEC campaign network. We have the same mandate. I mean, it has always been that. We even have regular MCLEs for purposes of updating our members, I mean, our fellow lawyers. And at the same, on the side of the SEC, it is also part of our mandate, which is to keep our investing public informed. Okay, everybody, I mean, for that matter, in the corporate world, to be constantly updated in terms of the updates in the laws which are being enforced and implemented by the SEC, as well as in the area of investor education. Now, since we have lawyers who are practitioners, corporate practitioners, as well as investors themselves, the kind of information that we have at the level of the SEC, and the kind of information that is there also at the level of the IBP, we can always share this information through this network. So malaking, there will be a lot of contribution that our IBP can do for our present collaboration. Thank you. And thank you, President Egon.
Thank you very much, Chair. And thank you, of course, to IBP, one of our supporters, and PICPA also happens to be a good friend of the Chair. Their president is Mr. Bato, Lope Bato, of course. Going back, we have two more questions, sir, from the chat group. The question is, can there be a one-member or one-person corporation for non-stock corporations? Is it applicable?
I think JB or Kelvin would like to answer that.
No, Chair. I think there's a specific provision in the RCC. One-person corporation refers only to stock, to business corporations. So non-stock not included, Chair. Yes, back to you, Jermaine.
Okay, I think there are a lot of messages and we'd just like to thank them. One message says, thank you for this webinar. This is very, very informative. We've been getting a lot of messages like this from Facebook, as well as that from our Zoom. And we'd like to thank you very much. As I said, we will be, before we end this webinar, we will be posting the SEC contact numbers. So in case you have further concerns, the contact numbers will be posted later on before we end, so that would now and we've also noted you for in the near future. Thank you very much. Just a reminder. So for those who have signed up in the SEC webinar, again, rest assured that the Commission has recorded your registration. We will send you an evaluation form later on, and this will be part of the verification process for us to issue your certificates, e-certificates. While for those who were not able to pre-register but attended the webinar, we will post the link for the evaluation form in our Facebook page so you can fill it up. Thank you very much. Thank you. I think this ends up and wraps up our question and answer. Thank you very much again for the very interactive